Okay, I'm going to take you through, this is a section of AC 1.2. What we're looking at is how the criminal justice system is organised. And as you can see from the title on this slide, I'm going to be looking at specifically the work of the courts, how the courts are organised. I'm going to deal with magistrates courts, crown courts, and then courts of appeal. So let's take you through this bit by bit. Hopefully this all makes sense. Lots of stuff in the textbooks that you could use. I've attached various links in this PowerPoint for you to use. I'm not going to use those links today, but I'm expecting you to go away and have a look at those links, and that will broaden your knowledge of some of the key cases that you need to be aware of. I can't stress enough that you have to have case studies. You need examples all the time to back up what you're evaluating as you go through this course. So always have case studies, always have specific cases that you can refer to. Today I'll be looking at stuff like Derek Bentley, the Guildford Four, the Birmingham Six, Sonny Clark. So really familiarise yourselves with the ins and outs of all those cases. Okay, let's have a look at our court system. You should be all right on how laws are created. And you should also be really clear on what the role of a judge is. And as we know, it's Parliament in general that make the law. Judges do make the law by setting judicial precedent or statutory interpretation, but in general, a judge's role is not to make law, but to uphold it and then apply the law which is made by Parliament. Now, we've already discussed in previous PowerPoints the difference between civil and criminal law. And there are, just as there are two types of law in the country, there are also two court systems in the United Kingdom. Okay, there's the civil court and the criminal court system. Right. You need to be really clear that for this part of the course, particularly Unit 4, when we're talking about the court system, we're primarily looking at the criminal court system and not the civil court system. So the expectation here, because you're studying criminology, is that we are looking at the criminal court system. So as we know, civil courts deal with civil disputes. That's normally private disputes between people or businesses, such as contractual differences, personal injury claims, that sort of stuff. Okay? But criminal courts, and this is the one that we need to focus on, deal with cases where a person has committed a criminal offence. So we're looking at stuff like theft, armed robbery. And the key thing with this is if they are found guilty in the court, the defendant will receive some sort of punishment. Now, you'll always get more marks in an exam by using correct or subject-specific terminology. And what I've highlighted here in bold is this phrase here, first instance. Now, it seems like a difficult concept, but actually it's very, very straightforward. There are two criminal courts of first instance. What do I mean by this? Well, it is what it says on the tin. When you are tried for the first time in the first instance, what court do you go to? And the reality is that if you have committed a criminal offence, you're going to end up in one of two places, and these are your courts of first instance. So these courts of first instance are a magistrate's court or a crown court. Okay, so your first trial, your first instance will always be in a magistrate's court or a crown court, but that will depend on how severe your offence is. And you need to understand how these court systems work and how they are related to the severity of an offence. Now, we know that there are different types of criminal offence, and actually criminal offences can be broadly classed into three distinct categories as far as the court is concerned. Now, you need to know these three areas of terminology, and you need to clearly understand what each means. So the first category of criminal offence are known as summary offences. Okay? Now, summary offence is a less serious offence. This is stuff like speeding, assault. And the key thing here is that all summary offences are heard in a magistrate's court. Now, if you think about it, you know, not paying your TV licence, it's about to be decriminalised, but at the moment it is criminal. Shoplifting, speeding, dangerous driving, assault, drunken disorderly, all these type of common offences will be heard as summary offences and therefore will be heard in magistrates court, which actually means that the vast majority of offences in this country will be tried in a magistrates court. So those are summary offences, always heard in a magistrates court, not as serious. The next category are triable either way offences. Now the clue is in the name, either way. Now we know that we've got two courts of the first instance, the Magistrates Court and the Crown Court, and they both try cases, and all this means is that they're slightly more serious, these offences, so there could be stuff like I put here, ABH, actual bodily harm and theft, but all it means is they could go either way. They could be heard in a Magistrates Court or they could be heard in a Crown Court, unlike a summary offence which is always heard in a magistrate's court. Okay, so a triable either way offence is a mid-level offence tried in either the magistrates or Crown, depending on the plea of the defendant and or the sentence that would need to be imposed. And I'm going to explain this in a little more detail. And the next category of offence is an indictable offence. These are the most serious offences such as murder, rape, and they can only be tried in a Crown Court. So indictable goes to Crown, summary goes to magistrates, and triable either way can go either way. That's the way to remember it. Okay. Now, how does this work? Well, I've forgotten. I should also add there's also a youth court division of the Magistrates Court, which where they deal with kids who are 10 to 18, but the category of offences still stay the same. So let's have a look further and let's look at our Magistrates Court. Now, please excuse the little bit of pen down the bottom, don't know how that's happened. Now, Magistrates Court is set out quite differently to what you may have seen in your normal TV court drama where there's a judge and a jury. Now, the magistrates, who are also known as justices of the peace, sit at a bench or behind a bench. There will be three of them, and this is known as a tribunal. Tri meaning three, tribunal. If you're up in front of a tribunal, you're in front of three people. And the reason there are three magistrates is because it's impossible to have a split decision. You know, they're either guilty or not guilty. Two for guilty, one for innocent, two for innocent, one for guilty. There will always be a decision. Now, what you may notice in this diagram is there's one thing that's missing, and that is there is no jury. So the first thing to note is that in a magistrate's court there is no jury. Okay? We've got a witness box. We've got a dock. So you know we've got where the defendant sits in the dock. We've got a prosecutor. We've got a defence. We've got the probation officer, we've got the press, and we've got the usher. There's no difference here from a normal Crown Court other than the fact that there is no jury here. Now, the key thing here, or the key two sets of people, are the magistrates and the court clerk. Now, the magistrates are known as lay people. That means they are not qualified legally. So anyone can become a magistrate. I think it's over the age of 21. So when I retire, I could go, if I pass the test, and become a magistrate. Just any normal member of public. The expert in the law is the court clerk, who will be a legally qualified person. And the court clerk is there to advise the magistrates on legal issues. So what you've got here is the magistrates who decide the guilt of the person and pass the sentence, and you've got the court clerk who advises on the legal issues surrounding the case. But The jury and the judge here are the magistrates. Okay, so let's look at this in a little more detail. Remember, magistrates can try summary offences and either way indictable offences. So as we move through on the Magistrates Court, remember summary, triable either way offences, and they're lay people, they're voluntary, they don't get paid, and they have to do 26 half days a year. Okay. Now the reality is, as you start to evaluate this, if you think about it, if you've got to give up your time 26 half days a year to hear cases, you're not paid for it. The reality is the vast majority of magistrates in this country are people who are retired, because most employers won't free up people to go and their employees to go and sit on a magistrate's bench for 26 half days a year and pay them. It's not going to happen. So one of the criticisms that's often levelled against the Magistrates Court is they're very age biased. They're skewed towards the older members of society, and therefore it doesn't give a true representation of society as a whole, and it's much more biased towards the old. You can make your own decisions about that as you go through. Later on in the course we will actually have a talk from some magistrates, and we will visit the Magistrates Courts and look at some of the cases that are there. So as I've said before, magistrates are also known as justices of the peace, and as I've also indicated to you, the vast majority of cases in our criminal justice system are heard in Magistrates Court. In fact, it's 97% of all cases. Now, one of the advantages of that is, number one, magistrates aren't paid, so they're cheap, and number two, there's no jury, so again, no expenses there. You've just got your defendant, your prosecution, your defence, probation officer, clerk, usher, etc. So it's a cheaper way of maintaining justice, okay, because there's less people involved. And in general, it's those summary offences such as antisocial behaviour, public health, enforcing fines, community punishments that they will deal with, okay. But the key thing here is, where cases require a penalty greater than magistrate sentencing powers, are sent to the Crown Courts. Now this is key, so you need to be really clear on what the magistrate's sentencing powers are. Okay, so you've got to be careful here, because the law has changed very recently and some of the textbooks will now be wrong. This is correct. Okay, so if you are tried in a magistrate's court, the maximum sentence they can give you is 6 months imprisonment, or if you've committed 2 or more sentences, they can go up to 12 months, so 2 6 months combined. It used to be that they had a limit of £5,000 for a fine. That has changed very recently in 2020, and now there is no limit on the fine that they can impose. So that's a change, and it's different from what's in the textbooks. So the key thing here, when we refer to this idea of a 6 months imprisonment, one of the reasons that you won't hear a rape case or a murder case held in a magistrate's court is because if you did hold it in a magistrate's court, the maximum sentence they could give is 6 months. So therefore, it has to go to the Crown Court, because these indictable offences are much more serious, much more serious. The other key thing to consider is, if you have a triable either way offence, yes, you have the right, any offence actually can be heard in a Crown Court. Everyone has the right to be tried in front of a jury. So if you were fined, if you were caught speeding, you could, if you so wished, demand to have your case heard in a Crown Court. However, as soon as you move to the Crown Court, you are much more likely to have, if found guilty, a higher fine and a higher sentence. So the risks are greater. And this is to sort of discourage people from demanding to have their case heard in a Crown Court. So you have a careful balancing act if you're the defendant in a magistrate's court, because if you choose to have your case heard in a Crown Court, you are also accepting the fact that it's very likely that the cost of the case, if you're found guilty, you'll be charged for, will be more expensive. The sentence you receive will be higher, and any fine you get will also be higher. So that's the way it is, okay? So when cases come to a magistrate's court, they will make a decision as to whether it can be heard, so is it a summary offence or a trial by either way offence, or they may make the decision that it is too severe for them, and the sentence that may be passed for that crime may be more than 6 months, in which case it will be referred to the Crown Court. Hopefully that all makes sense now. So what does a Crown Court look like? Well, very similar to a magistrate's court, other than the fact that you will have these 12 people here, a jury. Now, as in a magistrate's court, a tribunal, there's 3 people, so you can't have a tied verdict. A jury has 12 people, so technically you could have a tied verdict, everyone going 6-all. Now, the first question you may ask is, well, why don't we have an odd number of jurors? And the plain answer of that is 12 jurors, 12 apostles of Jesus. It is based on religion, that there were 12 apostles and therefore 12 disciples for Jesus, therefore 12 people in a jury. And that is the reason it's an even number. Okay, so we have the judge, and as we know, the judge's role here in a Crown Court is to ensure that proceedings are carried out fairly, but his role is not, I cannot stress this enough, not to find the defendant guilty or not guilty. It is the role of the jury over here to find the defendant guilty or not guilty. Once they have found him guilty or not guilty, or her guilty or not guilty, it's up to the judge to pass the sentence. So you've got the judge here, you've got the jury here. Once again, you'll have a prosecution barrister. He will be employed by the Crown Prosecution Service, just as the prosecution barrister in the Magistrates Court will be employed by the Crown Prosecution Service. You've got the defence barrister, you've then got the press, just in a Magistrates Court, the public, just as in a Magistrates Court, the defendant, just as in a Magistrate Court, ushers and witnesses. So the only thing that's different is instead of the court clerk, you have the judge, because there's your legal expert, and instead of the magistrates, you have the jury, because they are the lay people who decide on the guilt. Okay, so what is quite interesting is that in both our courts, both magistrates and Crown Courts, it is the lay people who decide on the guilt, whether they're guilty or not guilty in general. Okay, it's not the legal professional. The job of the legal professional is to argue the case legally and ensure that fairness occurs at all times. Okay, so let's look at our Crown Court in more detail. We know already that judges' decisions are really important because legal precedents can be set for future cases. Okay, and of course we know that when sentencing, judges will use precedents set in previous cases to ensure that the sentence they carry out matches sentences that have gone before. And what this allows to do is allows the law to develop consistently and fairly so that all cases are treated the same. Everyone's equal in the eyes of the law. So that's your magistrate and your Crown Court, but also there's a third court, and these are called appellate courts. You might also know them as courts of appeal. And the key thing here is that, we know that every now and again the criminal justice system gets it wrong. And occasionally people are convicted of crimes they didn't commit or are sentenced too harshly or inappropriately. You often hear the press complain about how a sentence isn't long enough, or alternatively, the sentence isn't long enough, the judge is being too lenient, or alternatively, it's too harsh. So you need to have some examples of miscarriages of justice. So I've given you some links to some videos you can watch. So one of the key cases you could get to know is the Derek Bentley case. His case is one of the ones which brought about perhaps the ending of capital punishment in this country. If you don't want to watch the YouTube documentaries, which I've given you a link to here, there's a very good film about the Derek Bentley case called Let Him Have It, and I have put an MP4 file of that in the shared work area so you can watch Let Him Have It. It's a very good film. I think you'll enjoy it. The other case you might want to get to grips with is the case of the Birmingham Six. Again, I've given you some links here via YouTube. Have a close look at this one. Very big case back in the 80s. And the other key case that's also linked to that is the case of the Guildford Four. Again, if you don't want to watch the documentary, there was a very good film called In the Name of the Father that details this entire case. Fantastic film, In the Name of the Father. I don't have a copy of it, but if you can get it on Netflix or Amazon Prime, have a go and see what you can do. In the Name of the Father, really good film. Another case you can look at is the case of Sonny Clark, and you're going to need this for Unit 3 as well. So really do some research, find out what happened with Sonny Clark. So, we know that occasionally our justice system gets it wrong. If they've got it wrong, what course of action does the defendant, the prosecution, etc. have? Well, they have the courts of appeal. Okay, so these avenues are open to defendants and the prosecution to have a look at appealing against a sentence and getting decisions reversed. So let's recap. What are our two courts of the first instance, where people are tried for the first time? We know it's the Magistrates Court and the Crown Court. And what kind of cases are tried in those courts? Well, we know it's summary offences in magistrates. It's either way, triable either way in both magistrate and Crown, and indictable in Crown Court. Okay, so with that in mind, I know my camera will be in the way of this, but down underneath me it just says Adult Court. So what you've got here is your Magistrates Court, which is where the case is started, and your Crown Court. And this diagram shows where your routes of appeal are from the various courts. Okay, so you need to refer to this appeals process as I go through the next few slides, just so you're clear of it. So you've got Court of Appeal, High Court Justice, Courts Martial, which is to do with military courts, but in general your Magistrate Court will either appeal up to the Crown Court or the Court of Appeal. The Crown Court will go straight to the Court of Appeal, but there's also a way of that moving up and down between the High Court of Justice, and I'll come to that in a bit of in a while. Okay, so all of the next few slides are referring back to this slide, which charts the various routes you can make between the different appeal routes. Okay, so let's start with our appeals for a Magistrates Court. Okay, so if you are the defendant and you feel that you haven't been treated fairly in a Magistrates Court, you have two routes. Okay, so the first route is, if you wish to appeal against the conviction or the sentence, so if you think the sentence is incorrect or you think your conviction is incorrect, the only route you can go is to the Crown Court. Okay, and only the defendant can do this. Okay, only the defendant can do it. The prosecution cannot. Okay, and when it goes to the Crown Court can either reverse the decision or vary the decision. So they might say, oh well, they fined you £5,000. No, that was wrong. It should be 2,500. They gave you a 6-month sentence. It should have been 3 months. Okay. If a defendant wishes to appeal by way of case stated, an appeal is made to the Divisional Court of the Queen's Bench Division. Okay. And this can be used by the defendant against a conviction or by prosecution if the defendant has been acquitted. So this route is not very used often. Okay. And what this is saying here, just to to translate what is some quite difficult legal language, what we're saying here is if the prosecution aren't happy with the decision the magistrates have made, so they may think the magistrates have been too lenient or they should have been convicted, their route that they must make is to go up. Okay, so the prosecution can move up to the divisional court. So if you go back and look at the diagram, you can see that route there. Okay, and it could also be that the defendant may feel that the case shouldn't have been heard in a magistrate's court, which is very strange, which should have been heard in a Crown Court. Though why you do that, I'm not sure. So that's why it happens so very, very rarely. Okay, and what the divisional court could do is confirm, vary, reverse, or transfer. Remit is the word they use. Transfer the case from one court to another. So it's another route. But in general, the appeal process from a magistrate's court is by a defendant to the Crown Court. This is only really used by the prosecution, and it's very rare indeed. Right, moving on. If we go for the Crown Court and you are the defence and you want to appeal, then there's a different route. You go straight to the Court of Appeal. Okay? And the most common appeal for that is against the conviction or the sentencing. So either there'll be, I was found guilty, I shouldn't have been, or you've given me a really long sentence, I shouldn't have been sentenced for this much. Okay? If a defendant wants to appeal, they've got to do that within 28 days of the conviction, and they've got to get permission to appeal from the Court of Appeal, or they've got to obtain a certificate from the trial judge. I've spelt that trail, it should say trial, that the case is fit for appeal. So if leave for appeal is granted, then it's heard at the Court of Appeal, and the following could happen. The appeal is quashed, so they allow the appeal, the conviction's quashed, they dismiss the appeal, the conviction stands, they decrease the sentence, they lower the conviction to a lesser offence, so you could have been moved, I don't know, you could be moved from grievous bodily harm, actual bodily harm, move the sentences around, or they could order a complete retrial. Okay. Now, one of the cases you could look at in how these appeals have worked is you could look at the Hillsborough disaster and the way that case was conducted and how that was reviewed. So you might want to have a little look at that, but you can also look at the Guildford Four, Birmingham Six and the Derek Bentley case as well. All of these went through some of these processes. Okay. If you're the prosecution, okay, you could also appeal. So the prosecution would be appealing decision from the Crown Court if they felt the defendant should have been found guilty and was found innocent, or the defendant should have received a harsher sentence than the one they got, then they have the right to appeal. Okay, they can only appeal if they have the permission of the Attorney General. Okay, and they have to go to the Supreme Court, and again, that is very rare. And the reason behind this is that actually in this country, as we know, you are innocent until proven guilty. It is the job of the Crown Prosecution Service to prove the guilt beyond reasonable doubt of the defendant. If they have failed to do their job, that's their fault. And therefore appealing against the fact you haven't done your job properly is counterintuitive, if that makes any sense. Okay? So really, the only sort of appeal you'll get will be on if a judge has made a mistake or a legal point, or if it's of general public importance. So it doesn't happen very often, but it does occasionally. So be aware of that. Okay? So your Court of Appeal hears appeals from the Crown Court. The Court of Appeal does not hear witnesses, but instead considers legal arguments, documentary evidence, and in that case the majority decision wins. The Supreme Court hears appeals in criminal cases from the Court of Appeal and the High Court, and an appeal will only be granted if a point of law or general public importance is involved. So in general, very few things are overturned, but it does happen and you need to be aware of those cases. Finally, my last slide, we have the Criminal Cases Review Commission, which is the CCRC. It's not a court, it's an independent body, and it was set up because what used to happen when we review criminal cases, they were actually looked at by the police, and it was felt that this should be more independent, and this was changed. So there were, as I put in my second bullet point here, there were a number of high-profile miscarriages of justice in the late 1980s. Oh, I don't know what they would be. Guildford Four, Birmingham Six. Okay, and they were set up. The CCRC was set up in 1997 to work through any allegations of miscarriages of justice, because it doesn't seem right for the police to investigate whether they've stitched up a criminal or not. It should be done by someone that's independent. Okay? And if the CCRC investigate a case and they feel that there's something iffy, they can refer the case to the Court of Appeal. Okay? And the sort of thing that the CCRC will look at will be fresh evidence or allegations of a miscarriage of justice. So what's the key thing you need to be aware of here with this AC? Well, you need to be really clear on your difference between who make up a magistrate's court and who make up a Crown Court. You need to be really clear on the 3 different types of offences. You need to be really clear about what the maximum sentencing powers are of the magistrate's court, for how big a fine can they give, how big a sentence could they give. You need to be really clear on the use of the word lay people, members of the public, and that in our justice system it's the public that decide the guilt. You need to be clear about the role of the judge in a court, and you need to be really clear on who the different people are: the defence barrister, the prosecution employed by the Crown Prosecution Service, the jury, the clerk to the court, ushers, etc., etc. And then you need to be vaguely clear, not vaguely clear, be clear on the different appeal routes there are. We don't tend to get a lot of questions in the exam on the appeal route, but just be familiar with where you can go if there is a miscarriage of justice. I hope that's helped. Thank you.